If you notice, Professor Rice was talking about the Constitution. I was speaking about procedural things like the motion for preliminary injunction. He talked about the Constitution. Mr. Schlafly spoke about statutes. The General spoke about a court decision. And we were taught in law school that the law is not just one statute. The law is a combination, a hierarchy of principles, and on top would be the Constitution of the United States. And believe it or not, they still teach that today in law schools. They still teach that the Constitution is the prime and the most important law of the land, and that under that you have treaties and statutes. But alongside with statutes are court decisions, the common law, which we get from England, the common law of England, and then the common law of the various sovereign states, or the federal common law on federal issues. And then the courts are also needed not only in making that common law and in changing it, but the courts are also used in interpreting the statutes of Congress, and interpreting the Constitution itself. And the statutes set up administrative agencies and allow them to make laws. And that's, we are told, is law as well. And we have even seen with OSHA that we even have administrative courts. And these hearing examiners are called administrative judges. Now, the administrative law can be as much of a law against you as any other law, and it can hurt. It can fine you. It can take away your rights and deprive you of property, deprive you of liberty. This administrative law, some of it is found in the Federal Register. But there are also other things which are not public, compliance manuals and policy letters, which are also used against you, and which, we are told in law school, also make up the law. Now, questions are raised when we try to place the law in perspective and discuss the various components of the law. And I hope that we have shown you how the various parts of the law work together. The question I have for the panel members is to discuss the constitutional implications of administrative law generally, and these bureaucratic agencies cranking out law. Appointed hearing examiners who are actually part of the very same agency that's prosecuting you, being called judges and acting like judges. And also the issue as to whether or not the courts should even review acts of Congress, which they have done since Marbury versus Madison in the early 1800s. Your comments first, Professor Rice.
On the administrative agency routine, you have a problem there of trying to preserve the separation of powers and at the same time trying to avoid having one body or one person be the judge, jury, and executioner and prosecutor in the same matter. This is something which is imperfectly worked out in the present statutes. They confer great authority on these agencies. OSHA is a good example. And I would say that perhaps the main reason for the exaggerated rulemaking authority in some of these agencies is the compliance of Congress, the complacency of Congress, where they have delegated tremendous powers to these agencies with no sufficient oversight. But I'm more concerned, because I think it's more particularly important at this time, with the other question is with respect to the power of the courts to review acts of Congress. I think the courts inherently have to have authority to decide cases. They have to have authority to decide constitutional cases. And if a statute conflicts with the Constitution, they have to have the authority to declare that that statute is unconstitutional. The problem is the binding effect of that decision. Unfortunately, in recent years, court decisions have taken on the character of something written on Mount Sinai on tablets of stone. And you get the idea that every time the Supreme Court, by a 5-4 or other majority, comes down with a ruling, that it's something that all of us have no choice about but to obey. And that just isn't true. You find that this attitude is very widespread in Congress as well as anywhere else. That there's just nothing we can do about a Supreme Court decision. Well, there is. You can ignore it. And to a great extent, many of these problems would be solved if Congress would refuse to accept Supreme Court decisions in some areas as the final word. In some cases, they can be overturned by simple statutes. For example, Pennsylvania against Nelson, which in the 1950s overturned all of the state sedition laws on the grounds that Congress intended to do it. It was a complete fabrication. Well, Congress lacked the fortitude to overturn the Supreme Court. This gets back to the idea that I was mentioning right at the beginning, which was simply that we tend to give too much respect to judicial decisions and to judges. We owe them respect properly on account of their office, but unfortunately on account of the way that some of them have misused their powers. I have in mind particularly these fakers who handed down this abortion decision. I think they are owed, while we reserve the respect due to the office, I think we ought to regard these people with utter contempt. And maybe it's about time for Congress to take on a little bit of that attitude, too.
Mr. Schlafly, would you tell us about the role of the judiciary in checks and balances and in separation of powers?
Yes, John. The judiciary was named by the Founding Fathers as a coordinate branch of government. Of course, the legislative, the executive, and the judiciary. It was not supreme, despite the name the Supreme Court. It was supposed to be at least on a coordinate or equal basis. But we have seen the Supreme Court take over the legislative functions and the executive functions. They are not just interpreting the law, they're making law. They're announcing this is going to be the law from here on after. It's supposed to be the law of the case, but now they tell us it's the law of the land, which is quite untrue. It's only the law of the case, but nevertheless they pronounce it, and they get many people to believe it's the law of the land. We have a very courageous Attorney General in Missouri by the name of John Danforth. He's, I don't know anybody here from Missouri, a show of hands, but he's a very devout Christian gentleman, and when the Supreme Court announced the abortion decisions on January 22, he just said, that's not the law of the land, that's the law of those two particular cases, one from Georgia and one from Texas. It's not the law in the Missouri, and I'm going to see that it's not the law of Missouri until the Missouri legislature acts or until Missouri courts act. The Supreme Court has not decided this question in Missouri. There's no case from Missouri involved. And we can go right through it. There is, of course, even a grave question was as to whether the Supreme Court could invalidate acts of Congress as unconstitutional. In the British system, and our judicial system was somewhat taken from the British, the courts cannot do that. No act of Parliament can be declared unconstitutional by the British courts. However, it was decided early in this country that in Marbury versus Madison that the Supreme Court could invalidate and declare unconstitutional acts of Congress. But they have gone far beyond that. And just for one example here, I have a list in the Cardinal Minzani report for May 1973 of some 50 cases where the Supreme Court knocked out the laws of this country protecting us against subversion, against communist espionage, in which the Supreme Court decreed that it was unconstitutional to forbid communists from teaching in our public schools, in which the Supreme Court said that you couldn't ask questions of witnesses put by congressional and state committees in regard to their communist backgrounds, in which the Supreme Court said that you had to issue a passport to a communist. They knocked out the laws Congress had passed saying you couldn't issue passports to communists to go back to Moscow and get some new instructions. They knocked out the enforcement of state sedition laws. They said, and I could go down a long list here of the decisions that the Supreme Court has made, just knocking huge gaps in the security programs of the United States. And those gaps are extremely serious. We have found out when they had the Moscow Treaty being negotiated by President Nixon last May, a year ago, in Moscow, in regard to the limiting nuclear weapons, that the Soviets have a submarine which is an exact copy of the Polaris submarine. Fires the same number of missiles, has the same nuclear type engines, an exact copy of it. Well, how did they get it? They got it through their espionage. And they're turning those things out. We haven't made any Polaris submarines for 4 or 5 years. The Russians are turning out, they estimate, about 15 of them a year. Exact copies of our best nuclear firing submarine. So if you're interested in that particular phase of what the Supreme Court has done, I suggest that you contact the Cardinal Manzini Foundation. I think they have a booth here, and for their report of May 1973, listing many of these Supreme Court decisions in regard to our national security. I couldn't help mentioning what Professor Rice said in regard to the, I begin to think I'm Fred OneNote here, getting back to the qualifications of the Supreme Court judges in which he said that. But there was one I overlooked mentioning to you. Now, here was a fellow who was appointed named to the Supreme Court, and he'd been a card-carrying, dues-paying, lifetime member of the Ku Klux Klan. He was a member when he was before the Senate to be confirmed. He had a lifetime card. He'd never resigned. And yet, because the patriots in this country, the religious people, were not on their toes, they were asleep, that man went on the court, and he was on the court for more than 30 years, and he did, from our standpoint at least, rendered a tremendous amount of unfortunate, and I will say wrong decisions in national security in particular. And I think you all know to whom I'm referring. He was on there almost as long as anybody had ever been on the Supreme Court. There's obvious reasons why that man wasn't qualified to be named the Supreme Court, but nobody did their homework, and in he breezed. And once, of course, he's on there permanently. Now, there are some suggestions made on that, what to do about it. One suggestion would be that the Supreme Court judge would have to come up for reconfirmation about every 10 years, or maybe every 6 years. Just like anybody else, the president, the senators, and so forth, they haven't got lifetime jobs. Why should we make one branch of our government all-powerful and standing way head and shoulders above all the other branches of our government? Why not keep them on the same level? Another thing would be that a Supreme Court could not declare an act unconstitutional by a simple 5-4 majority. If they're going to do something as grave as that, why, we better have more than just one man on the thing. Maybe it ought to be, I'm not even sure 7-2 is right in view of what happened last January. Maybe it better be 8-1 or all 9 of them. But there are lots of ways it could be done to restrain the power that the Supreme Court has usurped. It's not in the Constitution, but they have simply usurped this power to decide upon their own basis of what they think should be, what the law should be. Thank you.
Thank you. Mr. Schlafly, you can stay right there because your microphone is working. I just have a short question for you. There are many acts of Congress that are unconstitutional right now. Should we go to the courts then and seek judicial review of those unconstitutional acts of Congress?
Yes. Is this on? It doesn't sound like it. No. I think so. And to get back to your favorite subject, John, let me tell you something. If I can tell you about your favorite subject, maybe not, but I take the advantage of my age here. When they show us how powerful some interests are. When the Food and Drug Act was originally passed, there was one interest that was so powerful that they simply prevented the food and drug from enforcement against that whole industry. And I don't know whether John knows what that industry is or not, but of course I'm referring to the liquor industry. You don't have to put on hard liquor that it's what alcohol does, that it's a poison, that it's habit forming, that it gives you serious addictions, that it's unhealthy to drink it, and so forth. They don't have that at all, not on any of the whiskey bottle. But let some little harmless vitamin come along there, and the Food and Drug will pounce on him and say, well, we don't agree with you on that vitamin. We're going to put that little harmless vitamin, even if you took 10 times the dosage recommended, it couldn't possibly hurt you. We're going to put you out of business. But here goes the alcohol business, and everybody knows what alcohol is and the harm it's caused and its addiction. And I'm not a prohibitionist, but it's just a plain fact. It's one of the main causes of addiction, and there's some 9 million alcoholics in this country that are undergoing, that their lives have been ruined by alcohol. But not one word of warning is put on the whiskey bottles. And if you want to read that, John, you turn to the Dr. John Wiley, who originally drafted the Food and Drug Administration. He was the first administrator, and he wrote a very bitter book, which has been little publicized and now out of print, and I'll lend you my copy.
Well, thank you. Thank you very much, Fred. I appreciate that offer, and thanks for sharing that with me. I hadn't realized that before, but that's true. And also, the tobacco industry is not regulated by the Food and Drug Administration either. How about that? Now, General Watts, you're a soldier as well as a lawyer. I believe that what we're fighting now with the law is a type of guerrilla legal warfare, and a guerrilla doesn't pass appropriations to get any weapons. He goes out and gets the weapons of the other guy. And I like to quote General Patton or George C. Scott from the movie. This dying for your country, there's a lot of crap. It's up to you to make the other guy die for his. And I ask General Watts if we should challenge these unconstitutional federal statutes in the courts and make them eat Marbury versus Madison.
John, I think within the limit of our time capability, it's great to keep these people as honest as we have the ability to do so. Unfortunately, the American people are faddists. Anything that fits in with the fad just gets the big build-up. Anything that doesn't fit the fad gets the downgrade. And without going with the stream, it's awfully hard, John, to pick these unconstitutional actions by the various branches, particularly of our federal government. Now, the basic problem with the law in America is that our court, particularly the United States Supreme Court, leading the way, is obsessed with the concept of privilege. In other words, the Dr. Spockism that has almost destroyed the youngsters coming on and made them an entertainment-oriented civilization has invaded our courts to the point that anything dealing with privilege gets the build-up. Anything that deals with duty, honor, country, responsibility gets the downgrade. I asked Fred to bring with him a copy of the advance sheets of the Federal Digest, which is a long shelf of books in which are published excerpts of the decisions of all federal courts in the United States. And as illustrative of the point I'm talking about, key number 90 under constitutional law deals with freedom of speech under the First Amendment. I can't resist reading to you that short First Amendment. So you'll realize how simple was the concept of the framers of our Constitution when they gave to the American people the basic right of freedom of speech. Here's what the framers of our great Constitution said. Congress shall make no law respecting an establishment of religion, and pursuant to that, the U.S. Supreme Court has held that you can't have a prayer in school, or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press. Now, all in the world the framers of our great document said was that the Congress shall make no law which abridges that. That simple language, in absolute violation of what Judge Owen told me years and years ago, that the judges who came to town in the horse and buggy had time to think, that simple language has been extended fantastically by the courts, primarily the federal courts in the United States. As I told you, this portion of a volume here is what we lawyers call advance sheets. Under constitutional law, there are many sections of legal concepts that are laid out in the digest, so we lawyers, when we want to get a precedent for some big, loud, sharp argument we're going to make, don't have to spend 2 weeks looking for a decision. We can go to this digest, find it immediately. Now, illustrative of this faddism that I was talking about, under freedom of speech, key number 90 of constitutional law, there are 57 pages of excerpted decisions over a period of 3 years. It's the most obese, I will say, for lack of a better term, section of the federal law. I can't resist giving you a typical example of the life and death constitutional issues that our Supreme Court spends hours and hours and hours studying the record, reading the law, writing decisions. Here's a case that came from California that is almost beyond comprehension. California, and this is just one of many, and this case goes on and on and on to protect the freedom of speech of a demonstrator. California had a law that says any time the exercise by one party of his freedom of speech invaded the sensibilities of his neighbor, that was a crime, and the perpetrator thereof should be punished. In other words, under the old saying, everybody has a right to freedom of speech. But that right does not go far enough to say that you can stand up in a crowded theater and yell fire. But now here's what this demonstrator did, and if you just want to win a lawsuit, John, all you need to do is be a demonstrator. This character was walking up and down in the courthouse in California in front of women and children with 2 huge signs on him saying 4 letter the draft. He was put where he belonged, in jail. The Supreme Court of California affirmed the conviction because that invalidly and illegally invaded the sensibilities of the people who were forced to look at that obscenity. Now it comes to the United States Supreme Court, the highest tribunal in our land, and for page after page after tedious page, they evaluate, they analyze, they study, they expand, they explore, they expand the right of freedom of speech. It just literally makes you want to break out in tears when you see how this poor character had been so oppressed by the state of California when he felt so intently about the draft and was not permitted to say so until the United States Supreme Court got a hold of it. Quote, where the defendant walked through the courthouse corridor wearing a jacket bearing the words 4 letter the draft, in a place where women and children were present, California lacked the power to punish the defendant for the underlying content of the message and the inscription conveyed, at least so long as there was no showing of an intent to incite disobedience. It went on to say that if he felt that way about the draft, he was sure entitled to say so. Now, folks, with that kind of faddism in the United States of America, with that kind of downgrading of the concept of duty, with that type of unbelievable expansion of the silly personal whims of the individual to say anything and do anything he wants to, how in the world can only 9 justices on one court have time to realize that America faces 2 problems? And I say this in the light of a very current, and I hope it's not a popular issue, but today, my friends, our great country faces 2 problems. Number 1, we're bankrupt. Number 2, we're almost defenseless. And in analysis and evaluation and the dedication of ourselves to the duty of solving those problems, we have spent over the past 3 weeks, or perhaps the past 2 months, 80% of our waking hours chasing water bugs. So I say to our fellow Americans, particularly my fellow lawyers, the time has come in America to wake up, to realize that we are letting slip through our fingers the greatest nation on the face of the earth. Let's return to a concept of simplicity, a concept of right and wrong, a concept of justice. Get the job done and get to work.
Well, we're not going to entertain questions, but I'll answer that. I'll answer that one. General wants to answer that one. General?
One time the guy got arrested for speeding. This big fine-looking patrolman drug him out of the car and says, "Mister, get out of that car and let me smell your breath. I think you're drunk." He said, "No, you don't. You smell my lawyer's breath." Call your lawyer.
Okay, good. I assume you're asking me that question as a member of the bar abiding by professional ethics, and you want my opinion as a lawyer. Well, as a lawyer, my opinion, if the OSHA man comes into your place of business without a warrant and he doesn't leave, punch him in the mouth. A lot of people have questions and posed questions to me earlier, and I'm trying to get through a lot of the questions that I've heard. We can't possibly entertain questions. One question that I'm sure a lot of you have is the effect of the recent Supreme Court decision on pornography that allows the states or the communities to develop their own standards. My view on that is that I don't think we're getting much from the Supreme Court at all. And I think that the community standards will now be what we've had in the past, and that rather than standards being improved, certain communities, who are lower than the national standard, will continue and increase the exoticness and the lucidity of pornographic literature, movies, and live shows. And I fear that what we are getting from the Supreme Court is no bargain at all. That we actually are being set up for pockets of pornography in this country because of the Supreme Court's ruling on community standards. Now, why is this so? The reason why this is so is because the American Smut Peddlers Association is going to be in there fighting, claiming that the standard in this section of Los Angeles or San Francisco or Berkeley or New York, this section has a low community standard. It's like Copenhagen or Hamburg or Bangkok, and therefore the Supreme Court should allow that community its own standard. And we're going to see pockets of pornography, I fear, worse than what we have now. General Watts, would you care to comment on this recent Supreme Court decision? I know you have studied it. General Watts.
I frankly have a file here that the county attorney of Oklahoma County prepared for me. He's really a crusader in endeavoring to eliminate some of this silly pornography. I really feel what we should do with it is to counterattack by showing how utterly stupid it is. However, there must be some protection that the law could give the family who do not have time under the present demands of society to supervise what their children do and do not do. Unfortunately, young people in America get 80 plus probably % of their motivations, actions, and reactions from their associates rather than from their family. Now, originally, the concepts of the courts of the United States were that the family was entitled to protection of the law to assist in avoiding the young people being saturated with destructive mental processes such as this vicious pornography puts on our children. I read a study a while back where some 80 to 96 or 8% of a person's actions and reactions come from deeply embedded subconscious thought habits. Now, where those thought habits come from pornography, even from sex education in schools, and all the other silly concentrations we have on the stupid and the immaterial, when it comes time when the chips are down, when life and death decisions are to be made by these people who are trained under those concepts, their thought habits, their computer will spin, will whirl, will finally come up with a silly conclusion unless there's some way we can figure out to eliminate this corrosive, cancerous infiltration into our body politic. I can't resist telling you a little story here. I'm sure you've all heard of Mr. H.L. Hunt, who is a very close ideological friend of mine. I was down visiting with him a couple of years ago. Oklahoma City had been getting a lot of silly publicity about sex education in our schools. It was just really making the front page on and on. Mr. Hunt was chiding me about it, said, "What in the world's happening in Oklahoma?" I said, Mr. Hunt, if these educators would just get 1/10 as antsy pants to teach Americanism in school as they are to teach sex, they wouldn't have time for this foolishness. The old man shook his head and said, "Clyde, I doubt it." Said, "Unless these educators get a whole lot more intent and more capable to teach sex than they have been to teach Americanism, we're going to have a nation of perverts in 10 years. So these are problems that face America today. Our courts have heretofore had an answer for them. Now, however, with 57 pages of decisions in 3 years, and these are excerpted decisions, each decision covers a little area about that much, devoted to freedom of speech, and freedom of speech includes the right to circulate ruthless, vicious, corrosive pornography. Some way, somehow, we must have an overwhelming uprisal among the people of the United States of America and tell these courts that we're going to restore the sanctity of the family and let the people select, rather than the courts select, what is good for our young people.
Fred Schlafly, would you comment on the recent Supreme Court decision about pornography and about pornography in general?
The recent decision is a little bit helpful. However, it was the Supreme Court that opened the floodgates to pornography in the series of decisions rendered back in 1965 and 1966, in which Justice Brennan, the alleged Catholic member of the Supreme Court, wrote the opinions. In that case, they had one involving memoirs of a woman of pleasure. It was about a London prostitute and her day-to-day doings and occurrences in her household of pleasure. And, of course, obviously, if anything could be pornographic, that would be it. The word pornographic means, translated from the Greek, means writings, graphos, writings about whores. That's what this book was. But it had been condemned in Boston and other places and got up to the Supreme Court, and they reversed all the lower court convictions. And Justice Brennan wrote the opinion in which he held that no, it was not obscene and it wasn't pornographic. And he then put into his opinion a definition of what it had to be obscene. And a fellow who was a lawyer named Charles Rembar, for the book, had the, I guess, lack of good taste to come out with his own book about a year or two later telling how he conned Justice Brennan into buying this phrase, which got the book off the hook and got all other pornographic material off the hook ever since then, until this slight change in the law came out this spring. But he said that he persuaded Brennan to adopt the phrase that a book or a play or a movie could not be pornographic unless it was utterly without redeeming social value. Utterly without redeeming social value. Even had that word is underlined, italicized in Brennan's opinion. So, in the book that was before the Supreme Court then, a couple hundred years, been considered one of the dirtiest books ever written, at the very last page of the book, the girl says she's going to reform and she's going to leave the whorehouse and she's giving up her career or profession. And so you see that he sees on that. It's not utterly without redeeming social value, and therefore the book is okay. And well, you couldn't prosecute anything after that. The Supreme Court says unless it's utterly without redeeming social value. Well, they did this spring drop that phrase, utterly without redeeming social value. Although they did leave another loophole in there. They said if it has value, has artistic value, and they threw in a new one. I never heard of political value. I don't know how an obscene thing could have political value, but maybe if you had something like they're having over in London, Clyde, where they're having these high cabinet officials are consorting with call girls, maybe that has political value, and that would be couldn't prosecute it. But that's the state of the law now. There is, I'm glad to report, a little improvement, and at least they think that they can prosecute now the hardcore X-rated material.
An example of pornography with political value, Fred, is the Dillingham case, Dillingham versus Maryland, where a hippie was arrested just outside of Washington for distributing the Washington Free Press, which showed a judge in a pornographic act, and in a very obscene act. And the judge, Judge Pugh, from the circuit of Montgomery County, he didn't find any redeeming social value in that, or redeeming political value, and neither did the other judges on the bench, or the Supreme Bench of Baltimore, which actually tried the case, and they found Dillingham guilty. But the Supreme Court of Maryland reversed and said that it did have redeeming political value. So that's an example, I guess, of redeeming political value. It was a rather funny cartoon. Now, Professor Rice, would you comment on obscenity in the Supreme Court and the First Amendment of the United States?
I tend to be against the first, even in favor of the last. As far as the decisions go, I agree with Fred that they offer some promise of improvement because they may, depending on how they're interpreted, lead the court to sustain jury verdicts as to what is obscene, because now the criterion is that there doesn't have to be this characteristic of utterly without redeeming social value, but rather the thing has to have serious artistic, literary, etc. value. And more importantly, is to be determined not by the national standard, but by a local standard. Now, we have to see how this works. If it works, that juries' verdicts are sustained more readily by the Supreme Court in the future, I think it will be a big plus. I suspect that's the way it's going to go, and I remain guardedly optimistic about it. I want to recur for just a moment. I just caught a phrase, and I know I'm nitpicking, and I know you didn't mean it this way, John, but you said, as all of us do at times, that the Constitution is the supreme law, and that's true as far as the human law is concerned. But you know, one of the reasons why we're so fouled up here is that we tend to regard the Constitution or any other human law as supreme. That's one of the reasons why we are in such a mess. In the school prayer decisions, for example, the Supreme Court decreed that government must try to remain neutral as between theism on the one hand and non-theism, including atheism and agnosticism on the other hand. But you can't do that. A little kid goes up and he asks the teacher, says, is the Declaration of Independence true when it says that there is a God? What is the teacher going to say? Justice Brennan said that the words "under God" in the Pledge of Allegiance are not necessarily unconstitutional. You've got to catch this because, as he said, they may merely mean that this nation was believed to have been founded under God. So you get the point that if the words are meant to be believed, they are unconstitutional. So the little kid goes up and says, hey, teach, is the Declaration of Independence true? And if she says, yes, there is a God, that's unconstitutional because it prefers theism. If she says, no, it is not true, there is no God, that's unconstitutional because it prefers atheism. So what is she going to say? Well, she says, get lost, kid, go home and ask your mother. That's really what she's going to say, but she cannot say. And the point is that the government is required to maintain a suspension of judgment on the very question of whether God exists. And I've got a theory about this, that This explains much of what's going on today. You have a generation of school children who have been educated without ever having the experience of seeing the state in the person of the agents of the state most closely connected with them, that is, the teachers. Acknowledge the existence of a standard higher than the state. I think that is extremely significant. If we want to turn this thing around, we're never going to do it by tinkering with laws, as necessary as that is. We're going to do it only if we go right back to the very beginning. For example, we're not going to succeed in adopting an abortion amendment unless we do so not on the basis that it works better or that abortion is distasteful. We're going to do it only if we do it on the basis that there is a higher law, a law of God, and that the rulings are contrary to that. And I know that this was not the way you intended it, because I've used the same phrasing myself. But we've got to remember that there is supposed to be, and not supposed to be, there is, in fact, a standard of right and wrong higher than the state. The state can be wrong, and we've seen ample evidence of that in recent years.
This wouldn't be a discussion of lawyers if there weren't any disagreement. I beg to disagree. I meant exactly what I said. We have enough trouble with this Supreme Court now interpreting the Constitution. I don't want them to get a hold of the law of God. Now, interestingly, on how much God do you need? What's the quantum of God to be present in school in order for the school district to violate the Constitution? Illinois case, Fred, Despain versus DeKalb County School District, where an Episcopal Sunday school teacher at Sunday school would sing that little ditty, "We thank you, God, for the flowers so sweet. We thank you, God, for the food we eat. We thank you, God, for everything." And she was upset about Shemp versus Abington Township. Being a good law-abiding citizen, she took the word God out of the prayer, and the kids would sing, "We thank you for the flowers so sweet. We thank you for the food we eat. We thank you for everything." Despain, who was an atheist, had his kids in that school, and the Despain family, went into the district court, and said that their constitutional rights were being violated. And the district court in Illinois said, well, this is de minimis non curat lex. There is not enough here for the law to trifle with. And it went on appeal to the Circuit Court of Appeals. And the Circuit Court said, when those little kids are saying, "We thank you," we know who they're thanking. Yeah. And so, if you even say thank you, that's too much God in the school, according to the Circuit Court. What is that, the Seventh Circuit, Fred?
Right.
Seventh Circuit, which includes Illinois. Now, on this subject and for closing remarks, for brief closing remarks on his part of the discussion, and later I'll call for brief closing remarks from the other speakers, if there's anything they would like to close with. Let's hear from General Watts on the subject of the First Amendment and obscenity. General.
John, I'm checking out this digest that we lawyers all look at to find out what is the latest expression by the court. I find one here, red hot and brand new, under date of March 19, 1973, Barbara Susan Papish versus the Board of Curators of the University of Missouri, Fred. The show me state, and boy, she showed them. I'll give you a little briefing first in the language of the court on who Miss Papish was.
I don't think you can read what she printed, Clyde.
Well, I'm just going to skip over that and leave that to the imagination.
You'll have to censor it as you go along.
Well, now, aren't you really imposing on my freedom of speech, Fred? Miss Papish was a 32-year-old graduate student, a semi-pro. I guess by that time she's a pro. Admitted to graduate school of the university in September '63. 5.5 years later, when the episode under consideration occurred, she was still pursuing her graduate degree. she was on, quote, academic probation because of, quote, prolonged submarginal academic progress. And since November 1, 1967, she had also been on the disciplinary probation for disseminating SDS literature. That put her in good standing. Found at a university hearing to have contained pornographic, indecent, and obscene words. This dissemination had occurred at a time when the university was hosting high school seniors and their parents. But disenchantment with Miss Papish's performance, understandable as it may be, is no justification for denial of her constitutional rights. Now, after 5.5 years of being a submarginal student, she was handing out a paper with a political cartoon on it, which depicted in all gruesome detail policemen physically raping the Statue of Liberty and the Goddess of Justice, leaving nothing to the imagination. Also, another headline story in this was entitled, Mother, so forth and so on, is acquitted. Up against the wall, Mother and so forth, was not constitutionally obscene or otherwise unprotected. Boy, let's protect it. Let's look after poor Miss Pappy. She's only been in school 5.5 years. Let's take care of her in the highest court in the land and see that her constitutional rights are protected. Folks, I say that the rights we need to protect is the right to work, the duty to be an American citizen, to live above and beyond the call of duty, for duty, honor, country, and endeavor desperately to salvage and recapture some of the greatness of our wonderful land before it may be too late.
General, thank you very much. It's always a pleasure to have an articulate speaker such as yourself on a subject as complex as the law has gotten to be. Someone who can make it simple for us as you do. Thank you very much, General. Mr. Schlafly, Fred, would you care to sum up, counsel?
Well, I think we must rely on prayer, we must rely on, and we must also rely on work. There's that old statement which we're all familiar. We should pray as though everything depended on God and work as though everything depended on our own efforts. And it's going to take even more of our own efforts, I think, than certainly in the past than we did by way of prayer to correct this situation. It can be corrected. The hour is so late and the situation is so serious that I think and hope that people will turn away a little bit from their pleasures to see with what we are confronted. We have fearful external enemies, and we have an internal decay that is alarming. We have devalued our money twice. Worse than that, we've devalued our morals. And unless we correct the moral devaluation that's gone on, the situation is hopeless. And we must do that through the courts and through the law and through the churches and through the educational system.
Professor Rice, do you have anything to say in closing, sir?
I'm going to ask you to do specific things. I'm going to ask you, if you will, to try to learn all that you can about what I am convinced is the determinative issue of this time. That is the question of whether the state can define innocent human beings as non-persons and permit them to be killed at the discretion of others. I'm going to ask you to learn about it if you don't know anything about it. I'm sure you do. But these are simple realities. This is not theology. This is not something that is abstract. You're dealing with the child in the womb. You're dealing with the baby. Here he is at 18 weeks sucking his thumb. Now, the reality is that under the law in the United States at this time, legally, it is estimated that 1.6 million of these innocent human beings will be legally killed this year. You have a simple reality here that simply must be reversed. The child, when he is aborted, feels pain, just as you and I. This is a photograph of the child in the womb. And there's no question about it. This is the photograph of the child after a D&C abortion. If you look at the middle, you can see the torso with the arms folded in the middle. At the bottom, you see the two legs, and the large mass over here on your right is the head, crushed. This is the reality of what it is. Now, I'm asking you to contact your local groups. They exist all over the country. This is a genuine grassroots movement. If you have any question about whom to contact or what to do, please let me know. If you want any information on it, please let me know. I'll be glad to send it to you. The only address you need is Notre Dame Law School, Notre Dame, Indiana. And I ask you very intently to get to work and do this. Because I think, I don't want to look at this thing as a negative thing. I think we're going to win this one. I really do. I've been all around the country on this, and I feel it. We are going to win this particular fight. And we're going to deal such a blow, really, to the secular humanist establishment that has taken over this country of ours, that I think we will begin the regeneration that we need. But as John Schmitz pointed out so often, and he is my candidate, I was prevented by the Indiana law from voting for him, but it was always 1976. But as John Schmitz pointed out, we can turn this thing around only if there is a total moral regeneration in this country. And this begins with each one of us. It is true that everything that we do, the hardest work that we do, is going to come to naught except through the power of God. And we are going to turn this thing around, this thing that is so foul, so contrary to what the Declaration of Independence called the law of nature and of nature's God. We're going to turn it around only with primary reliance on what the Declaration called divine providence. And we are going to do it. We're going to win. We are not going to compromise. The amendments are there. Jesse Helms, Larry Hogan have introduced them. We're going to win it. We're going to go all the way. If I can help you, if I can give you any information, please let me know. But please get to work on this particular issue. There is no more important issue, and pray. Thank you.
Thank you, Professor Charles Rice, for speaking here and for aiding us with your scholarship. Thank you very much. Thank you, Mr. Schlafly, for speaking here and aiding us with the lessons that you have learned as an experienced trial and appellate lawyer. In closing, ladies and gentlemen, in summation, if you will, let me point out to this 11th annual New England Rally for God, Family, and Country that many of us, that each of us have different views. We are diverse and divergent, but we have a lot in common. Do you know what we have in common? Our enemies. We have them in common. And we may disagree on tactics, but we do have our enemies in common. And what we heard today was a way to use the law and a way for lawyers and laymen to work together. In closing, I would like to point out that the laymen have a responsibility here to support in every way they can the use of the courts, a watchdog on the federal judiciary, and a watchdog on Congress to make sure that they are properly regulating the federal judiciary. You know, the Congress has the power to regulate the federal judiciary, and the federal judges only have power because Congress has passed an act that says the United States District Court shall have the power to. They are creatures of Congress, and we must keep an eye on Congress and on the federal judiciary. Laymen, non-lawyers, can also do this. If the federal government wants to create courts, which are not courts, courts and administrative agencies, then laymen should be there practicing. After all, they're non-courts. What's wrong with having non-lawyers in there? Now, what can the non-lawyer do in an administrative agency? Citizens for Truth and Nutrition, a group that I represent that is exhibiting here, has a truth kit for its members. In that truth kit is a form letter to send to the program director of the network or station that is lying about an issue, a controversial issue. You write to the station, you say, I would like equal time for fair treatment, and you have to get those words in, fair treatment of controversial issues. If it's refused, what Citizens for Truth and Nutrition does is provide its members with a form that starts off before the Federal Communications Commission, Washington, D.C. complaint. It is a complaint before the Federal Communications Commission, and you fill in the blanks. And you, a layman, a non-lawyer, can have that lying radio or TV station or network before the Federal Communications Commission, and that's a federal case, and that's a hassle for them. You can do things like that. You can jam up this bureaucracy. You can take advantage of every administrative nook and cranny that you have and enact like OSHA. And if anybody says anything about it, if the judge says anything like, you're tying up the courts, you say, no, Judge, I'm not tying up the courts. OSHA is tying up the courts. And we have with the judicial branch of the government, a branch of the government that has not served us, and it should serve us, and let's use it. And it'll get depressing at times. I know that I occasionally feel depressed in this battle. And I ask you, when that happens, to do what I do, and to do it now with me, and to dream. To dream about a nation with healthy children, with a government that does not pester the individual citizen, a government that does not interfere with our daily lives and with our businesses, a government that only protects us from transgressions on our rights. Dream about a government that shuts down the lawbreakers and puts away the violent criminals, protects the citizen instead of closing down health food stores or preventing a doctor from healing. And I tell you that that dream is more real than your despair. As General Washington found out, it is just across the Delaware. Thank you for your attention, ladies and gentlemen. Now let's hear, ladies and gentlemen, a round of applause for Professor Rice. For Mr. Fred Schlafly. For General Clyde Watts. And for Colonel Bunker.